morning to everyone watching us today. This is Melisa Elkaya with another episode of Future of Europe. Today we're exploring the intricate intersection of European financial regulations and data protection concerns. Joining us is Marina Danielyan, a master's student in international and European law from Catholic University of Lille.
Hello, Melisa. I'm glad to be here.
Marina, with your expertise in this field, could you walk us through the regulatory frameworks surrounding the resolution of financial institutions within the EU, particularly in the light of a significant case, Banco Popular, and its implications for data protection?
Absolutely, Melisa. The situation with Banco Popular involves a lot of legal language. But essentially, it's about how the European Union handles big financial issues with banks. They have rules and procedures in place for situations like this one, which aims to protect everyone, so people like creditors, shareholders, and so on. Now, in the modern age, this kind of issues are intertwined with data, which complicates things quite a bit. So think about how much of our financial lives these days are online. There are a lot of concerns about keeping this information safe, which sadly did not happen for the creditors and shareholders and other parties involved within the resolution of this bank. So, in simpler terms, nowadays protecting the creditors and shareholders involves not only fulfilling the financial obligations, but also the protection of their personal data.
Explained like this, it's quite understandable, but can you elaborate more on the facts and proceedings of this case?
Certainly. So the events surrounding Banco Popular's resolution in 2017 were significant and complex, and they involved a lot of legal proceedings. So the Single Resolution Board made a pivotal decision which set out a resolution scheme for Banco Popular. This one was executed under the regulation number 806/2014, a key EU regulation governing the resolution on financial institutions. Simultaneously, the European Commission endorsed the SRB's resolution scheme, further solidifying the process for the bank's resolution. The SRB's decision to place Banco Popular under resolution involved careful steps, like selling some of the shares and paying out the creditors. Following the resolution, Deloitte, a company that specializes in auditing, accounting, but also many services that involve financial consulting, was requested to provide a valuation report asserting whether shareholders and creditors would have fared better if the bank went through normal insolvency proceedings. In the meantime, the SRB implemented the right to be heard process. You'll ask, what is the right to be heard process? This is a legal procedure that allows the affected parties to express their views, concerns, objections regarding the questions that directly affect their rights and obligations. Shortly after, challenges arose regarding data protection and information disclosure. Complaints were raised to the European Data Protection Supervisor, and these complaints were found a lot of non-compliance with data protection regulations.
That sounds quite intense. So could you provide further insights into the legal arguments presented in the court?
Of course. So in support of its action, the SRB, the Single Resolution Board, relies on two legal arguments. The first is that the information transmitted to Deloitte constituted personal data, even though it was deemed to be pseudonymized. And the second one is the infringement of the right to good administration enshrined in Article 41 of the Charter of the Fundamental Rights of the European Union. The EDPS, in its turn, argues that the comments from the affected shareholders and creditors are indeed personal data because they reflect the personal views, even if based on publicly available information. These comments could influence the rights and the obligations and further on affect the interests of these people that are affected. So the purpose of collecting these comments was to ensure procedural fairness and gather individual perspectives and not harm them in any way. With the arguments brought by the SRB, they are claiming that they are not going against just a specific decision, but they have to stand up for broader principles of data protection and equitable treatment.
So, with all that being said, what was the court's stance on all these matters?
That's a great question. So, regarding the SRB arguments that the information transmitted to Deloitte did constitute personal data, the court analyzed a regulation, which is the Regulation 2018/1725. And according to this regulation, personal data is the data that makes the natural person in question identified. So, such information as the address, the name, physiological factors, social factors, or economic, and so on and so forth, can identify this person. And the court found flaws in the EDPS's assessment of this data and concluded that further examination is definitely needed.
So you talked about things like personal data, anonymization, pseudonymization of data, but that sounds almost gibberish to me. Could you explain the concepts, please?
I understand how this can get tricky, and I would like to make it simpler for everybody. So let's give out some definitions. There are three concepts that we really need to get acquainted with to understand what's going on. Personal data, as mentioned before, is the kind of data that makes the person discoverable. So it means that, for example, if I know your name, your address, your contacts, and I can identify you through this is your personal data. And further on, we have anonymization. Anonymization is basically coding this data in a way that even if I put really a lot of effort and gain more information about you, I still cannot decode this data about you. And the last but not least is pseudonymization. So this is like giving a fake name to the data. So it means that we're kind of disguising this data, but it means that if I put the effort, the money, and the time, I can still decipher this data and I can know who you are. The court's decision in the SRB versus EDPS case majorly revolved around understanding whether the data that was transmitted to Deloitte constituted personal data or not. So the Single Resolution Board argued that it didn't constitute as personal data because it was pseudonymized, but that was not enough. I'd like to talk about a little bit of academic opinions, such as Michael Fink and Frank Pellis, that emphasize that even indirect identifiers can qualify as personal data under the General Data Protection Regulation. The court, drawing from the regulation mentioned above, concluded that the pseudonymized data could be considered personal data, even though because it can potentially be linked to an individual and it can help them find out easily who these people are. So the court rejected the EDPS's argument that no, this is not personal data. So it made clear that it was one. So, however, the challenges persist in defining personal data definitively. The distinction between personal and non-personal data is becoming increasingly blurry because the evolving landscape of data governance keeps creating new regulations. For instance, we have the Data Governance Act, which introduces a new concept as highly sensitive non-personal data, which raises really a lot of questions. So the SRB versus EDPS case serves as a catalyst for scholarly inquiry, prompting critical examination and debate over the boundaries of personal data and the protection in the EU.
All of this is very insightful. And the last and the main question is, how will this affect the future of Europe?
Well, this is indeed the principal question that we have, and I think the case will have a significant effect in many ways. So firstly, the legal clarity and consistency is kind of the effect that we're looking for after legal disputes as such. So as interpretations of data protection laws become clearer, individuals, organizations, and businesses will be able to understand clearer their legal obligations and rights when it comes to personal data. Secondly, technological innovation is discussed as discussed in this case, will help to understand better how to have pseudonymization in their technological aspects, and companies may invest more in advancing pseudonymization techniques in order to comply and to make their platforms more utile and secure. Furthermore, regulatory frameworks are adapting based on legal outcomes and academic discussions. So regulators may update guidelines and policies addressing these emerging challenges and issues. Moreover, clarity on the definition of personal data and pseudonymization has implications for international data identifiers. The EU stance on data protection influences negotiations on a more global scale, which is very important. Additionally, these discussions contribute to strengthening privacy concerns and empowering individuals to assert control over their own personal data. Clearer definitions and stronger enforcement mechanisms enhance transparency and accountability, fostering greater trust in digital services and platforms. And in conclusion, Europe's evolution of data protection laws and practices reflects a global trend towards prioritizing privacy and data concerns. By navigating complex legal and technological landscapes, Europe can continue to lead in shaping a future where individuals' privacy rights are respected and upheld in the digital modern age.
Well, I think we learned quite a bit about data protection today. Thank you for your time, Marina.
My pleasure, Melisa.
And that wraps up another insightful episode of Future of Europe. See you in the next episode.